Good evening, everyone. I thank everyone, all the participants and the jury for joining the session. So let me just give me a brief introduction about our speakers today. So this is the day 2 of Active Pharmaceutical Ingredients and IP Protection by Mr. Caleb Gabriel and Dr. Chitra Arvind, supported by Lex IP Care LLP in collaboration with CII TNTDPC and ISCRD India. So let me just give you a brief introduction about Mr. Caleb Gabriel. He is the managing partner and practicing as an advocate and patent attorney in India for the past 40 years. He has prosecuted more than thousands of patents applications in all fields. He has been a partner in a few leading IP firms in India, including Reformary, Sagar, Law Lahiri, and others. Also been a founding partner of the patent team and the heads of patent in K&S partners for more than. So we welcome you, Mr. Gabriel, for the session. So the next speaker that we have for the session is Dr. Chitra Arvind, who is a partner at Lex IP Care LLP. She holds PhD Pharma, MBA, PhD IPR, LLP in LLB Advocate, Registered Indian Patent Agent. Dr. Chitra holds MS degree in Pharmacy with specialization in natural products from National Institute of Pharmaceutical Education and Research, Naipur, Chandigarh. And her doctorate is in the field of natural products for the same institute in 2005. She has also completed her bachelor's in pharmacy from Dr. MGR Medical University, Tamil Nadu in 1999. We also welcome you, ma'am, for the panel, for being a part of the speaker journey, the day 1 and day 2. So before we start with day 2, during our feedback session, we had received a question from one of informant and defense perspective to API. Could you explain, please, more about API portfolio initiation building respective to synthesis patent for a known drug? So this was a request. I will also put the same question in the chat box for your reference. So if possible, you can cater this in the end of the session.
Thank you, Karthik, for your introduction. We have divided.
Yes, sir. Over to you. You can start.
Thank you, and good evening to each and everyone. And with this subject, APIs and IPRs, we have divided into two parts. Yesterday, in fact, we handled the first part, and today is the continuation of the first part. Yesterday, we discussed about the protection of APIs through various forms of IPRs. You know, there are various kinds of IPRs, how to protect APIs through various forms of IPRs. And then, of course, trickle down into specifics like patentability of APIs, especially in India, then initiation and portfolio building in developing APIs. Today, probably we will be covering about the opportunities and challenges of exploiting and protecting APIs in India, and if time permits, we'll stretch it to the worldwide availability of the protection and challenges. That's one. So to start with the opportunities for Indian companies while patenting APIs, that's So by way of introduction, see, APIs are a very important pharmaceutical ingredients for the Indian pharma companies. There are various pharma products will be available, like formulations, various dosage forms, and etc. By APIs per se form bulk and very important part of the Indian pharmaceutical companies. And in fact, almost more than 80% of the Indian pharma companies deal with APIs. That's the reason that now we give importance to the APIs here in this session. And not only the involvement of APIs by the Indian companies, but also the surrounding, the atmosphere is also very conducive for the Indian pharma companies to deal with APIs because we have a huge local population. And you need to cater the entire population with our medical needs and drugs. And many of the Indian companies target just India, and they don't even care for other countries in the world because the market accepts so much. And India has got the largest and scientific technical pool of people. So we don't need to bring technicians and experts from outside. Rather, we can get these experts locally, even in India, and they are available in plenty. So that is one of the important advantage of the Indian companies to deal with APIs. And of course, we know that India is not a very expensive jurisdiction, and then cost-effective manufacturing is definitely possible in India. And I mean, there are very, very few countries in the world where we probably can equate ourselves in terms of cost effectiveness, such as China and India. But when compared with other jurisdictions like United States and Europe, there is no match. And we'll definitely able to manufacture and cater the needs and provide the supply of drugs at a much, much cost-effective manner. And then also, we have a very robust import and export mechanism, wherein which there are so many concessions available for foreign exchange earnings. There are so many other privileges and benefits for local manufacturing. And this is available. So we have import and export mechanism available. And then we have bilaterals and multilateral agreements with various countries. As a result, we are able to easily export and also import the APIs and the ingredients which could form part of the APIs. And then also the scope for backward and forward integration of the Indian companies. This is an important aspect because what happens, the companies, the Indian companies, now they don't play only in India. They are now the global players. They go across and start buying companies and acquiring companies there. And then also the Indian companies not only export large quantities of APIs, but also import the APIs into India in order to make various kinds of other products like formulations, etc. And then also the Indian companies do set up manufacturing centers in various other companies. I remember when we represented Ranbaxy, which is no more now, and they had 8 manufacturing centers across the world. And also many other companies do have their own setups in other countries, but the technology flowed from India. And that's so the way they're manufacturing APIs, they have adapted even in those other countries in order to supply and cater the APIs to the local population in those countries. And as regards the import of APIs, we know that we do import quite a large quantums and varieties of APIs from China. And this is the thing which probably the Indian pharmaceutical companies will have to take cognizance, will have to think about it, because why should we import the APIs from China and other countries? Why not we manufacture such APIs in India itself? And there can be some hurdles. Nevertheless, we need to negotiate with the government, and then also ask for some concessions so that we are able to manufacture those APIs which we have been importing from other countries, because it's possible to do those things even in India itself. For example, during the patent time, we had a problem regarding import of the APIs from China. We do not know. Tomorrow, China might even stop supplying or manufacturing the APIs, and they may not cater to the needs of the Indian companies. So we need to be self-sufficient in order to now provide the APIs, because APIs cannot be compared with any other ingredients. For example, we have something short supply of oil. We have alternative energy. But if APIs are not available, then where would you go to provide the drugs and medicine to the population? That's the reason that we need to do APIs at our own place. Probably it's a dialogue. We need to have the government to make it conducive for us to manufacture all these APIs in India. And we have the opportunities. We have divided the opportunity into two categories. One is the self-created opportunities, and how the companies themselves can have create opportunities for themselves for the better IPR protections. And one is the jurisdiction aspect of IPR protection for APIs. As we discussed even earlier, mostly all the IPRs are territorial. They are limited to a particular territory, country-specific IPRs, except one or two, like copyright. Suppose if you are a member of Universal Copyright Convention or Madrid Massachusetts Convention, then what you develop copyright here, it is protected in other member countries. But that's not whole good. That's not applicable for other kinds of IPRs, like patents and designs. We have to get the patents and designs in the respective country where you wanted to do commerce, where you wanted to protect it. So that is the most important thing. And here it is, patent, it's a negative right. Of course, it's got its positive right, but more focused towards the negativeness of the patent. Why? Because when you get a patent, you block that particular patent subject matter for the entire population of the country, including the government of India. So that is the power of a patent. And then that's why whenever the patent amendment comes to the parliament, it is highly political. And because of the strength of the right. Some negative aspects, and patent has got a more negative aspect than the positive aspect. What are the positive aspects? If I have a patent, I have a right to manufacture. That nobody can stop it. But only patent gives a right to stop others manufacturing my patented invention without my consent. That is most important. And then, of course, the patent owners has a right to go to the court and then stop anyone for making, using, selling, or importing any of the product. Patent is subject matter. So it's a most important aspect that in a product or a process, making, using, selling, importing, or the important commercial aspects of any product. And that's the reason that the patent gives the owner the exclusive right to do that. And the other aspect which we wanted to focus is the patent does not give you the freedom to operate. As I said, it's a negative right. Of course, the positive right is for you to manufacture the patent subject matter, but with certain conditions and terms. And that's why we wanted to specifically mention that patent doesn't mean you have the freedom to operate. Patent rights and freedom to operate are two different concepts. Freedom to operate is, are you entitled to operate, manufacture, deal with that particular subject matter, either kind of product or a process in a particular jurisdiction. Patent gives the monopoly. But at the same time, you may have a patent, but you are not able to manufacture the patented subject matter. Even yesterday, Dr. Chitra has given some examples. She has given, there are patents filed for intermediates, and then also patent filed for the final product. So what is it? Patents for the intermediates have been protected. At the same time, the end product, the final product is also protected. Make the end product without the intermediates. Therefore, what happens? You might develop the final product, but you cannot manufacture the final product. You can even get a patent for the final product or an improved version of the final product, but you cannot manufacture that infringing the starting things have been covered there. So that's the reason that we need to be careful that before exploiting a freedom, bring it to the notice that before you want to commercialize or exploiting the patent. Then there is the worldwide examination. This is even yesterday we discussed it. The novelty is universal, but the protection is territorial. So this is what we need to be. So if you have to file a patent, see that your patent is novel, inventive, it's a worldwide right. The patent doesn't give anybody the worldwide right. Patents are territorial. You have to go to each and every country and so that's what is most important. You can't or you can't enforce so people normally think that a patent, that means I have a worldwide patent. There is no concept like worldwide patent so far. And it will keep everyone else from competing with us. So if I get a patent, nobody will come near me. That's not true. Because if you get a patent, you're announcing that you have a monopoly. There is always room for people to come near you and then try to do something. Many times when a patent has been granted, people try to work around the patent. And then so that they will also be able to take advantage of your information and at the same time work around so that they could fall out of the scope of the claims of your patent. So it's not that you get a patent, you're keeping people far away. Probably you'll be attracting people closer to you. And that is always happens. So the myth that I get a patent, I can sleep. No, you can't do that. And then this other is the government will give us money for as a reward. That's not true. If your invention is excellent, probably you will get some other title and other things. But there can be R&D and other things. Can government fund will have to be done by the companies and the person wanted to get the patent. That is what almost 95% of cases. And exploitation wide across the country, not a patent in patented technologies to exploit, make it available worldwide. In that context, what we have to do that is that we have to seek the license. We have to go and find out who would take my patent so that we are able to work it out. You can work out better terms of license with those guys in order to exploit it. Patents ought to be. So that's the thing. My see, there are certain companies when running to those the patent is for license. For example, Gilead. Gilead got a patent and the drug for and not only Indian companies, but also companies worldwide wanted to have a license from Gilead, and then even license to matter. That is an exception. Otherwise, it you try to seek licenses in order to make it exploitable as much as possible. The other myth is that we must have it. It is not necessary that you need to have a patent. Doesn't mean that no, everything ought to be patented. It's not so. Patents are a commercial tool. It's a gateway for your commercial exploitation. And then whenever you come out with an invention, and then you ought to get the patent first, because you can't go and exploit the patent before filing. That's a law. But it's not necessary that everything will have to be patented. It's not necessary. You have to see that which are the patents have got commercial potential. To make money, to build your goodwill. And that is important and things like that. So that every invention, every development, every small thing you do ought to be patented. It's not correct. It's not necessary. These are the things. But what are the truth? Not limited to major technological breakthrough. In other words, patents are not for great invention. Of course, it can cover the great inventions, but even the simple inventions could be covered under the patent. There is a case where a bend in the needle was such where the patent office rejected that no, there is no merit to the patent. Later on, the court said that there is a merit, and then they directed the patent office to give the patent for the inventor. Simplicity of an invention is not a bar for patentability. So please don't think that your invention ought to be really great. It becomes great because you have made it, not because it ought to be great, and then not and you're dealing with that. It's not like that. Every invention has got its own merit and got its own, and all small building blocks make the great things. So it's the thought that your invention will have to be path breaking. It ought to be always a new chemical entity. It ought to be a Nobel Prize winning. Don't. Every improvement, 99% of patents are granted. So that is the point. So when you make an invention, you see it's got a commercial potential, go ahead for a patent. And a non-exclusive to big players. It is not so. Of course, the big players file hundreds of patents. And then chain of patents are filed by those guys. But it's not just limited only to the big guys. It is meant for every inventor, even for a small time inventors. They can go to the patent office and get their patent, invention patentable subject matter. So the myth that the patent game is a big guy's game. It's not for me. Don't consider that. It is open to everybody to get the monopoly. And the other the thing is that when a product is profitable, there are increased stages of litigation. That is true. The truth is that if a product is a blockbuster drug, it's high value drug, there will a lot of guys will try to exploit, try to pinch a little bit of that right from you. So profitability, the commercial value is one of the attraction for outsiders to come closer to you and try to take a little bit from your side. I think, in fact, we have noticed that many of the pre-grant and post-grant oppositions are filed for the blackbuster drugs. So that is the important thing which you have to think like that. The other one is that the publication and patenting can coexist. And that yesterday, Dr. Chitra explained that you need to file first. The rule of first filing the patent is important. You first file and then go to the market, go and do your publication. And the truth is that the patent and publication coexist. What does it mean by it? You can file your patent, you can go and publish it, but don't do the publication before you are filing of the patent. That is the lesson we need to do that. And patent itself is the best publication. It is available to everyone under the sun by the click of a button. Your publication in journal may not be available. It is not that easily accessible, but a patent text is available to everyone and it is kept. It will be available even after 100 years. So the patent is the best publication and both can coexist, but you care to be there, don't publish before you file. That's the only thing. And it's a marketing decision based on long-term returns. So whenever you think of a patent, it's always the long-term, it's not a short-term. You have to do that next. And then the self-barrier, this is what I discussed earlier, that you invent, apply for a protection, that's like filing a patent application, then you go and disclose it. Next. And the other thing is the steps of filing patents. The step of filing is, see, we have check for patentability across the globe, as I discussed it. And then for a patent to be granted in any country, it has to be novel across the globe. So the novelty is universal. And then the second thing is filing in country of inventorship residency. This is a very peculiar requirement. If a person is a resident of India and if he makes an invention in India, you ought to first file in India, or you ought to get a foreign filing license before you file his invention first abroad. In other words, if an invention is made in India, then it ought to be disclosed to the patent office first and get the permission before you file your patent application outside for the first time. First, the other way is that you first file in India, wait for 6 weeks. Then, if there is no objection, no issue from the patent office, you can go and file your application abroad. But if you don't want to follow that, get a foreign filing license. If an invention made it in India, get a foreign filing license. And then you go and first file your application in other countries, including PC. That is that particular kind of law is available in many countries. It's not in all countries. It is in India, it is in the United States, but it's not in Germany and other countries. For example, if a German makes an invention in Germany, he has a right to go and file first anywhere. It's not necessary you have to first file in Germany and then do that. So it is country-wise. It depends on that. But in India, we have the first filing requirement. In India, if it invention made, it is there. So you have to be careful about it. And then the second thing is check for countries. Yeah, if you don't do that, you lose your patent right in India. But there is also a penal provision. So we have to be careful about the invention made in India. When the invention made in India, you first file in India, wait for 6 weeks, or get a foreign filing license before you first file your application. That's one thing. The second, the other option is that see, your invention is in India. You have the variations. You wanted to file your application, wanted to get the protection only and it's the national application. And the national application means you first file in India and get the patent in India, no other country, and be happy in exporting that invention, the patent in India. The other option is that you wanted to exploit your invention in other countries as well. So there are two routes available, as I have mentioned here. The first route is the Paris Convention. You first file your application, and then what you do that you within 12 months time you file your application in other countries, what you call Paris Convention countries. So you have an application first filed in India. Within 12 months, this invention can be filed in other countries. You get a priority. What is a priority? Priority means the novelty and inventory test will be done from the date of Indian filing. That is the priority, the date you get it. And then so within 12 months, you file your corresponding application in other countries. The other channel is that the PCT route. That is also a treaty. Mentioned, India is also a member of the Patent Cooperation Treaty, the PCT route. And what the advantage is that once you file an application, that could be your priority application. From that, within 12 months, you can file your PCT, and thereafter, you can file your national application within 30 months or 31 months, and then that's how you can take it forward. So literally, you have three routes: exclusive only India. Second thing is first you file your Indian application, and then under the Paris Convention, you go and file your corresponding application selectively wherever you want. The third route is the PCT. This is how you have to select and file. Depends on your interest. Depends on the various other terms and conditions. You can staggering up to 30 months for PCT. Here, the timeline, the priority of application. Whenever I talk about the priority application, two ways of protecting your invention. One is called a provisional application. You can file a provisional application in India or wherever you want. You can file a provisional application in India. What does it mean by provisional application? You are but some more extra work to be done. But so long a patent application to start with and get the date of filing, because the date of filing is so important. The first file gets all the right. The people who file subsequently get nothing. So the date of filing, you have to get the date of filing. You can file a provisional application. Then you can add some more information, some data, some tables, furthermore experimentation, and file your complete. Filing the so what happened? Your priority application can be a provisional application or it can be a complete application. Once the inventory according to you will file a complete. State away you file complete also, but the option to file a provisional within 12 months time, you can file your complete, but the date of filing is the date of the provisional application. So the priority application can be either provisional or it can be complete. Whichever you first file, then you have to go for your Paris Convention or within 12 months. That's what. If you months, you that's what we need to do that. The applications filed in any patent will get published. That's an 18 months publication is there. This is the important thing. That's an 18 months. Every application you file, it get published, but it was getting published after 18 months. So what happened? This the 18 months period is a dark period. That is always say that given a firm or when it does this data, the 18 months applications which have been filed will not be available for search, other things. In fact, sometimes there can be some issues because they are not published. No one will be knowing about there's already an invention filed in some country or it's filed in India. And it has happened in one of the cases where we have filed a provisional application for Indian Institute of Science. The invention is to solidify the hydrocarbons. So they are putting an additive into the hydrocarbon. It gets solid and things like that. We filed the patent provisional application for Indian Institute of Science, Bangalore, for that one. And then we had to file our complete after 12 months. By the time a lot of information has been added, and when you went through for filing the complete, we wanted to do a search. When we conducted a search, we found one Japanese patent which has been filed about 1 year back, identifying our own invention. So what happens? That 18 months period is a dark period. No one can predict, but we need to take the risk. We have to take a risk and file the application. So the data publication is important. That is the time the patent application is disclosed to the world. The next is if you have a PCT loop, then you have the PCT 30 months and 31 months. And then once you file a PCT or you file a Paris Convention application, then there is a examination. The patents are not granted by the PCT office. Patents are always granted by the national offices. So the PCT filing is not a granting office. It's not a granting procedure. It is only a filing procedure. And then, but to get a patent, you have to file a national phase application in every country and get it prosecuted and get a patent in that country for that protection. That's all we have to do. It takes anything between 3 to 5 years from either the PCT filing or from the Paris Convention filing. This is what the next is the portfolio planning. What is the portfolio planning? Relating to mental health. So what happened? These are the things or emerging areas wherein which you need to focus. You wanted to put your money. You want to put your effort and all the things. So is the most important thing. And what I wanted to invent, what I wanted to protect it, how I want to go to the market, which are the countries I want to focus, and then also what are the things I need to do that. So don't have a haphazard strategy. Your strategy should be a focused strategy and well-advised strategy. The second important point is timing is so critical and important. And because, as we have mentioned, that you can't publish it and go on patent. You have to systematically action. And if you miss any, so you need to time it systematically that what I want to do first, and the second and third, you have to know put a calendar and work on it. And that's the important thing. And then it's not that you file a patent or even you get a patent, it's enough. No, not at all. You need to follow it up. What is the following up? That you have a patent, see to that your patent is not infringed by others, or your patent is not no misused, that sort of a thing. You need every IPR ought to be supervised. You have to monitor that one. Otherwise, probably no. As yesterday, Dr. Chitra was telling that you will be diluting or you lose your trademark. Like that, even your patent becomes invalid because 100 people are infringing it. You don't take action about it. So you need to follow up. Getting a patent alone is not sufficient. You have to improve on the patent. You need to improve on the patent to find a you know that another guy will file an improved version. So because anybody can file a patent, you can improve on go and file and then get a patent for improved version. If you don't do that, others will get it. So we have to be careful. So the opportunity, the advantage, the applicant for a patent in India can be faced in prosecution stage. See, you file a patent application. It takes time. It takes few years before it could be examined and then get your patent. But at the same time, you can get an early grant by taking certain steps. What you call one of the India is one of the fastest examining jurisdiction. I can compare that earlier used to take 8 years to get the first examination to get it examined. It takes something like 4 to 6 months time to get a case examined. You are what you call RFP because examination file. You get in 6 months time first examination. Biggest jurisdiction in the world. Even USA doesn't issue such early examination. And India, we get some of the area of technology like mechanical inventions. There's a zero pendency before the Indian Patent Office. So you file your patent, you file your request for examination. In 6 months' time, you will get your first examination. You will meet the examiner's requirements, you get your patent. So that's what important thing. And bear in mind that the applicant cannot be granted before completion of the 6 months. See that 6 months buffer time from the publication. So every application you file before the patent office get published. They take 18 months to publish it. But there are provision to early publications possible. But whenever an application is published, you have to wait for 6 months. And a patent will not be granted before 6 months time. So you have to statutorily wait 6 months from the date of publication to get a patent. That is the things. And then you can ask for an early publication. Earlier I said that 18 months time, but you don't need to wait for 18 months. You can request the patent office, file a special request with a fees, official fee. Then the patent office will publish your application in 3 months' time or in 4 months. You find the request for examination, it's some time. But to be issued, then you ask an early examination. There's a special request for it. And then so that the thing is that you have the integrated examination proceedings available in India. We can examination. And here this the new program and the rule 24C, the Indian patents rule, has been very clear about it. And then it is not certain category. Like if an applicant is a startup company or if it's a small entity, what is the small entity? We have small scale industries. So in case of small industry and have asked for eligibility to our early examination, that is possible. And the applicant is a natural person. If it is an individual, it's a natural person. They also fall as the eligibility category. And then, or an institution established by a central government or a provincial government, and that is if the government entities, they can ask for early qualification or early examination. Uh, and the same thing, the government companies or the institution wholly or substantially financed by these are some of the categories of the applicants who can ask for early examination. And so the other category of early examination is that if an application is a PC application, which is filed in India, and if you get in the ISR, the International Searching or International Preliminary and Examination Report from the Indian Patent Office, then even that applicant can ask for the early examination of the application. Once you ask for the early examination and then early publication, then within 3 to 6 months time, you have to file your response and get your patent granted. If you are diligent, you're able to get a patent granted in 8 to 9 months time. And then here is rights of the patentee. The patentee has got exclusive right. See, what are the rights of the patent? So you get a patent. What you get out of that? These are the this is the right which has been provided to every under the statute. Section 48 is very clear of the Indian Patent Act. It says that consent of the patentee, anybody who does make, use, offer for sale, selling or importing the patented subject matter or the product. The same thing is available even for a process. So the A is relating to the product, the B is specifically for the process. And whatever it is, anybody who commercially exploits, that means offer to sell, import, export, or anything of the patent subject matter, these are the rights given to them. And next slide, next. When the rights are given to them, these are the exclusive right. And when the exclusive right is given, that is your right. Somebody interferes with the right, the cause of action. The cause of action is called infringement. In fact, the Patent Act has not defined what is or the patent is very clearly given. So we need to be careful, but there are differences. But certain actions and activities of third parties will not constitute an infringement. What are those? See what kind of defenses available against infringement. So there are the section 107 is very, very clear. What are the exceptions from the patent rights? That's what here it's very clearly given. And then every ground on which it may be revoked under the section 40. So if a patent has been, then what happened? Any third party, any interested, everybody, any third party has got a right to revoke a patent. revoke a patent means there are various grounds given under section 67. Uh, 64 of the Patents Act, grounds given. We can state High Court and look at the things. The other is any suit for infringement of patent by updating the process exception. Yeah. What is section 47? The section 47 gives certain rights to governments. It's very clearly mentioned that the government can import or make any of point on behalf of the government or so the patent matter, the patent drug can be imported by government of India for its section 47 on behalf of the government for purposes mainly for own use. 47.1 by the government, 47.2 on behalf of the government. But for the targeted purposes, mainly experiment. The first is for the government, for governmental purposes, or agents of the government can use it. The other, the exception 3, 47.3 is an important exception for patent rights. These exceptions are experiment or research subject matter. These research over the subject matter. And then also there's another instruction teaching. I can take subject matter existing pattern and then start teaching and then for academic purposes. And then these are the you have and exclusion, and also cutting instruction or teaching exclusion from the patent rights. Then the other one is that the central government can use any agents, the public service, and then using a dispensary or hospital or medical it is being protected under the subject matter of the patent to do the and then to serve and supply those drugs to the kingdom. But the government will have to gazette or notify. These are the institutions are authorized to exploit this particular patent. So such exploitation will not enter into infringement. So one more thing is here, certain acts not to be considered as infringement for the purposes of that. Here is an exception there, reasonably related to the development and submission of information recorded under any law for the time being in force in India and also in a country other than India that regulates and manufactures use, sale, or import of any of the product. So, what is this? This exception is for? This is a very peculiar exception, in which the exception are called a Bolar-like provision. This exception is called the Bolar-like provision in India, and then it's been now section 104A. Had an exception that is called the research exception. It's what called the exception. also gives an example to research. There are research exemption, but the present law has made it much more specific and clearly defined what sort of actions those are. And this Bolar provision, Bolar-like provision, is started with the US law. It's just from US law. The Bolar exemption was given to there's a very famous hatch in and its provisions under the hatchback like that. It also brought private government issue. For example, if an invention made out of government fund and the invention will go back to the government. Hatch-Waxman made an element in respect of the government private parties do those things. And at the same time, it also brought in the Bolar exception. And then this is what the things. For Hatch-Waxman Act, even there is a provision called the experimental use doctrine was in USA, but it has been firmed in by this the Hatch-Waxman Act. And so any data information you create in order to get a regulatory approval is an exception to the patent infringement. That is the crux of this text. So it's very this provision has got mentioned trips. The Article 30 has provided a provision for such exception, like the Bolar provisions in the Article 30 clearly says that the member may provide limited exception, can provide a limited exception for the exclusive right. But what are those limited exception can be provision is so the base requirement that regulation must be obtained for APIs, and so there are the conditions. Whenever a product will have to get a regulatory approval, they are entitled for the what are those products? APIs. So whenever you want to put an API into the market, you know, from the drug controller or from the FDA, you have to get the approval. And without approvals, you can't go to the market. And such approvals, such as cosmetics. And then on the other hand, if I make a mechanical device, and then I have a patent for a mechanical device, I manufacture and straight away go to the market. I don't need to go through any regulatory approvals. But an API cannot be done. An agrochemical cannot be done. Some of the case, those then the Bolar provision is applicable, wherein which you have to get a regulatory approval. Here is a patent, and then the patent's got a limited term. It's got a maximum of 20 years term, and in addition to that, you have to get a regulatory approval. Anybody wanted to go to the patent or go to the market. The issue is the natural justice. In other words, a person obtains a patent. If a patent 20 years old, the patent might expire, in 20 years term. And then thereafter, if the generic, any third party wanted to manufacture the product, they have to go. They can't straight away go to the market. They have to do the regulatory approvals. The regulatory approvals might take many years, but the public cannot wait for the availability of the cheap drugs. And that's the reason that prepared to work third party, any generics want to do that, they can do that during the so that they can go to the market one price. And that is the based on the equitable principles and things like that. Yeah. So this is the well accepted principle, not only in India, and that's a thing. And there is we have a case where Bayer versus Alembic, which has been very clearly given that there is certain conditions for this the Bolar exception, or applying the Bolar provision. The patent must be granted. The nature of the product attempt to be exported, like the nature of the product is important. And then also the details of the parties importing the patented product. You have to disclose these details of the thing. It's not, see, this exception is a limited exception wherein which you can manufacture, you can import, you can sell the patented subject matter in order to create data, research information data, so that you can get the regulatory approval. Thereby, you will be able to launch the generic version of the patent subject matter as soon as the patent expires. But this exception should not be misused. In other words, this exception is not for commercial exploitation. And then that's why we need to be careful on other things. You have to manufacture, export that quantum of the patented subject matter, the drug, only to create and develop and generate the data and nothing beyond that. But any other commercial activities, pilferage and selling and reaching into the market, stockpiling, all these are prohibited. So we need to be careful about that one. And then other particulars concerning the end use of the products is important. So, for example, for research purposes, for creating a data, you want about 3 kilos of an API, which has been covered in a patent. But if it's 3 kilos, you make 100 kilos, then you need to account for the remaining thing. Okay, fine. 3 kilos is sufficient enough to create a data, create enough information in order to sell, to get a regulatory approval, even get a regulatory approval. But why that 97 kilos, where the substance, what for it is? So that is, you are accountable for that. On particulars relating to the relevant regulations, which include quantum of the product, is so important. That's also we need to do other things like that. Issue is that though it is available, see, the Bolar provision is very unique. You can manufacture, you can sell, you can import, export. Is exactly all commercial activities being made. And the question is that it's not a sale. When you sell it, you're making, and it is only in India the sale has been accepted. In other countries, you can manufacture, you can import and other things, but sale has not been given in USA. In India, it's like that. Though when you sell it, you make a money out of that. But how much you sell it, what is the sale? It is the sale is only restricted to any party who in turn could create only the data and nothing beyond that. So there is a very careful, we need to think like that. Also includes export to regulatory purposes. If the purpose of sale is experiment or research and is in line with the legal requirement, of the export country, then the Bolar provision will be applied. For example, see, Bolar permission, you can use it in order to uh, exploit a patent in India, but you wanted to export to some other country. If that country do not have a Bolar permission, then you have a problem. Your product can sail through your borders, but it cannot enter into the exporting country because in turn they do not have the Bolar like provisions in that country. So your product cannot reach the target. So we need to be very careful about it. And then not only we have the Bolar provision, see to that the importing country do have the provision of the Bolar provision so that it can sail smooth. You are able to exploit the Bolar provision here and manufacture and export. In turn, you have you have the counterpart, the importing country do have the Bolar provision so that your product can sail through through the borders and reach the target. There one, but all countries do not have Bolar-like provisions. For example, in Russia, the exception is only last 3 years of the term of the patent. But Bolar provisions are applicable from the first day of the granting the patent. So we have to be careful. You have to study when you're going to export your under Bolar provision. Please see to that the importer also do have such provisions. Okay, next, importation into a country. It's all products. It is already there. This is already. Yeah. Challenges, barriers, opportunities, company license, other provisions. So this is we have provisions like the patent oppositions. Oppositions are available for even other IPRs, but the patent oppositions are very peculiar. It causes various kinds of oppositions and things like that. And why oppositions there? Especially the pre-grant oppositions. Why it is pre-grant is provided is that the essence is that wrong patent should not be granted to any party, because patents being powerful rights, it blocks the entire country from dealing with a particular patent subject matter. Therefore, the wrong patent should not be granted to an unscrupulous people. So there's an opportunity given to the public. So, because the patent rights are against the public. It's a monopoly given against the public. So there's have to be a public participation. So the public has got a role in order to grant the patent, not only the patent office. Of course, patent office is to grant patents, but the public also have a right because the interest is also against the public or in favor of the public. So that's the reason that public is given an opportunity to see to that good patents are granted. And that's the reason that, so the external support rendered to the patent office. See, patent office do examine, but they're not, the patent office is not experts. The patent controllers are not experts, other things like that. But they do examine, there are also technical guys. There are highly skilled guys. But patent office alone should not be given the entire right to grant patent. There have to be a filter. The filter ought to be provided by the public. And then therefore, the public participation is important. That is the reason that they say that. And the can be abused, expensive and lengthy to see if a patent rights is given. Revoking a patent is a costly affair. You have to go to the High Court and revoke a patent. The long drawn battle. But when the inception, if a bad patent can be nipped, it can be removed, it is better. That's why we have the opposition argument. The entire burden should not place on the patent office. That is what the thing. But what happened? The provision to prevent misuse should not be used to prevent getting the patent. That's what is happening nowadays. And then we will be talking about this one, other thing. So we have provisions for opposition. We have a pre-grant grant and post-grant under section 25(1) and 25(2) of the Indian Patents Act. And then all the grounds has been codified there. Wrongful assignment, patent, rightful person don't get the patent. They don't get the patent, but a wrong guy gets a patent. So all these things can be challenged before the patent office by the third party, by an opponent, so that the right patents are granted to the right parties. That's it. So the distinction between pre and post grant oppositions are here. In case of pre grant under section 25(1), I have given the grounds of opposition, the variant, the challenge and novelty, inventive step, and all that. But this is relating the procedure, the process by which how a pre grant, who should be filing a pre grant, and this is what the slide refers to. And then we have a form section 78. That is the notice of opposition. Then always the pre-grant can be filed after publication, not before publication. But before publication, nobody knows there's a patent there, patent application is there. So after publication, you can launch your pre-grant opposition, and there's no fee, there's no official fee there. And then also, when there's a pre-grant patent, there's no question of infringement, because the infringement comes after grant, not before grant. So the infringement proceedings can start once a patent has been granted, not before that. Things like that. And then the second thing is the prayer permits the hearing. For example, in case of pre-grant opposition, if an opponent, pre-grant opponent, asks for a hearing, then the patent controller, the patent office ought to give a hearing to us. So in other words, whenever a pre-grant opponent asks for a hearing, it's an inter-party proceedings. And then the patent office ought to hear the applicant, patent office ought to hear the opponent, and then take a decision. So it is mostly it is an inter-party proceeding. And then the pre-grant, as I said, by any person, it need not be an interested party. There's a distinction between an interested person and any person, and that means the applicant cannot ask the locus standi, ask the status of the opponent, whether the opponent has got any interest in application or it's frivolous. He cannot question it. Any person can file a pre-grant opposition, and then there's a contrast in the post-grant. We will come for that. And then whenever there's a request asked, the controller will have to hear both the parties and pass an order or make a decision in this way. And what kinds of relief? The relief can be either the patent application be rejected as a whole, or if there's a merit in the patent application, the opposition will be rejected. The third option is that there can be a limitation of the claims. The claims are very broad when it was filed, and then at the time of opposition, the claims can be limited so that it can sail through the opposition. So these are three possibilities in a pre-grant and procedures. And regarding the post-grant, and then the starting period is after the grant. After the patent has been granted, within 1 year from the date of grant, post-grant can be filed, and there is definitely an official fee. It's a voluntary act, and the party for the post-grant ought to be an interested party. What is an interested party has been defined in section 2(1)(t) of the Indian Patents Act, and then the interested party has got some sort of interest in that particular interest, in the sense that if a patent has been granted, his business will be affected, or his research will be affected, or his other aspects of commerce will be affected. So he doesn't want the patent to be granted because of various grounds, and then so the interest will have to be expressed by the interested party while filing the post-grant opposition. That will have to be there. And then the other is that there will be a hearing. There'll be a hearing. There's a hearing. It's a must in case of post-grant. And then the procedure is slightly different. Once the post-grant opposition is filed, the file will be referred to a board constituted by a senior examiners or controllers. Then the board will provide an opinion to the hearing officer. Whereas in case of pre-grant, there's no board. The controller who's examined the case will also consider the pre-grant opposition. Sometimes the pre-grant, the prosecution and the pre-grant can be merged and considered together. That's it. In case of post-grant, since a patent has already been granted, the file will be referred to a board. The board will give a recommendation to the controller how to deal with it. And the merit of the case, the board will give it. It's got a novelty, inventive step, and all the things. They'll give a guidance. Thereafter, the controller will hear both the sides and pass an order. The order can be, as I mentioned, that either he rejects the post-grant, or it can be he can grant the patent the patent, or he might even restrict the claims of the granted patent. That's the things. And then there can be a cost in case of post-grant, whereas there's no cost of grant cost in the pre-grant. There was there was a little issue in case of the pre-grant. The law was silent whether once the pre-grant decision is issued, can they file an appeal or they can file only a writ. But the provisions are silent about it. But later on, the court case clarified that they have a right to file an appeal. And that's why there are so many appeals filed before IPAB that is there. The other issue in case of pre-grant is that it is considered to be a sort of draconian, because there is no specific, the time limit given is from the date of publication till the date of grant. That window is too broad. And then as a result, this triggers filing of a serial opposition, pre-grant oppositions. And then one after another, people file the pre-grant opposition. And second thing is that it need not be filed by any interested party. So any party can file a pre-grant and halt the prosecution of this application and grant of the application. So this is considered as a sort of a draconian, because when people file a patent application and see to that whether if it's got a merit, it's not a granted. If there's a merit, it can be rejected. But when there's a merit, why an application will be held for years and years under the pre-grant opposition? It also adds burden to the patent office. The same controller will have to hear each and every party, because it's an inter-party. So if there are 10 oppositions, you ought to have 10 hearings in case of 5 years and 10 years, and then hear the parties and pass an order. And before he passes an order, another guy will file a pre-grant and halt it. So that sort of delays the grant of the patent. Whenever even a meritorious case, patent applications are held in the. And in fact, we have a few bad experience. Of course, we also file a lot of pre-grant, but in one or two cases where the patents have been granted after literally around 15th year, or one patent granted just 2 years ago, 18th year of the term of the patent is granted. I think, but it's got its own merit. Because of the multiple pre-grants, there was enormous delay. So that is what the things. So this is the case. Next. So we have right to file an appeal when there's a pre-grant, but IPAB has been now scrapped. So we have to go to the High Court to file an appeal. And this is the next. Then we have the revocation of the patent. We talked about the opposition, pre and post grant, some of the aspects of those, and then now the revocation. Revocation of the patent is not new area. It's been there ever since the 1970 Act is there. The patent can be revoked The grounds of revocation is clearly given under Section 64, and then the public interest. Here, not under provision of the Act is not useful, and because to have a patent, not only novelty invent is done, but also should have a utility, and then obtained by false suggestion or false representation, and that is important thing. These are the extra grounds of revocation apart from the opposition. Opposition, there are overlapping grounds, but certain extra grounds under revocation, like the false representation. He has given, he has put a table which is not correct. Based on that, the patent office granted a patent office. So a patent can be revoked if there's a false, because the patents are contract of good faith. I make certain statement, I make some tables and data. The patent office believes on it until contrary to natural nature and other things. But the patent office believes on it and grants a patent. And if any false statement, any wrongful statement will go to the root of the patent and the patent gets cancelled. So this is what the contravenes certain provisions, like we have secrecy order and then also defense and etc. If anyone contravenes Section 35 secrecy order, and that can be also a ground for revocation. This one, next slide. And it can be revoked next. And public interest. So patents can be revoked on public interest. And essentially, government has got all the rights to go to the patent office and ask them to revoke a patent. There again, the have been patented. And then in those cases, then the patent office can go and based on the granted, here is the Indian patent 168950, method of producing the transform. In fact, seeds and tissues are all not patent subject matter. And then by mistake, there's a patent granted. The government went to the patent office and revoked it. Same thing. Next, a patent has been granted, arrested, and a combination of three natural products, jamun and this is the functional ingredients has been used. This combination is already known. It is so traditional. It's done as remedy. And into the patent office to revoke. So on public interest, a patent can be revoked. Next. By just to get the company and keep it. It thought to be exploited. That is the reason for using the patent or working the patent, non-working of it for revocation. And so what will happen if it not worked? The government to the patent office and revoke. But how to say that a patent is, we need to file what we call a working statement every year. Statement, it's a detail of the patent. The patent or even a election. If you don't do that, then what happens? There can be a penalty. penalty means they can up to 10,000. Not they can put a fine, and these are the things the patent office can do that. But at the same time, it shows that you are not exploited the patent, therefore it can be removed. That is what it is. One is the compulsory license. The compulsory license is another exception for the patent rights. What is a compulsory license? It's been we have got section 92 very clearly says that the provisions, special provision for compulsory license notified by the government. The government gives a notification, and then as a result, it provides the license to the various people of the patented subject matter. And 92A, compulsory license for export of pharmaceutical product in. So 92A, certain exceptional conditions for pharmaceutical products. Next. So here's also, it's called sanctioned by TRIPS. Even TRIPS, Article 31 says that non-voluntary license and also license for domestic production without authorization of the right holder and for national emergencies, extreme urgency for process can be met, and the Yoga declaration also is part of, is subsequent to the TRIPS exception based on the. So these are we have the international sanction, the law, failure to work the patent and public interest. These are some of the reasons can be granted. And then the compulsory license case. There are so many cases regarding that. For manufacturing and export, wanted to manufacture, and this license has been, this application has been cancelled or set aside because they have not provided enough data. They have not provided enough information in order to why they wanted the license and that sort of thing. They're not serious about getting the license, and to get a commercial license, the licensee ought to get ought to make an effort to get the volunteer license. That is one of the preconditions. So you can't straight away go to the patent controller that I want a compulsory license for a particular patent. You can't do that. There are stepwise processes prescribed under that. You have to go to the patentee and seek a volunteer license on a reasonable terms and conditions. In case if you're not able to secure a volunteer license, if the guy who got a patent who are not commercially exploited the patent, he refused to give a volunteer license. And ask intervene and give a compulsory license. The other one also, 2 applications filed, the grant of a volunteer license. Even this application, and then no, Cipla for Merck, this this has been considered because the high price and therefore makes it inaccessible to patents in India, not followed by there's no compulsory license because they have already given a voluntary license. Then comes the Musmaya scheme, where it means here again there was an application for a compulsory license. That the monthly therapy of the drug is INR 1 lakh. Then now the claim that selling the drug for 8,100 for a month therapy. Unfortunately, the prima facie has not been made out by the license seeker, and as a result, it was not given. The license was not given, and then also the other issue that the health ministry planning to give the license for this particular drug, and as a result, these guys are simply withdrawn the possible no national emergency or national urgency exists. Therefore, there is no a license given to that for this particular case. Next, the things here again, there is a license application made, but of course there's a patent. The things like that. The license application could not mature, cannot be granted because of the procedural issues. And then also they have not made a solid case out of that. But what happened? The litigation, the Viacom, along with the US patent. Then what happened? They have asked for the Roche decision not to pursue the Indian patent number in India. So since there's they don't wanted to wanted to get the patent rights, don't wanted to enforce the patent rights, and then therefore the composer license was not there, and then of course the matter started a different turn, different twist in this case. The litigation was later on, a litigation was point, and it spun over into the areas of biosimilars. And then what happened? Then Roche was able to halt the Biocon and others under the other provisions of IPR, like there's the trademark, because they're trying to use their trademark, which has been protected, and then also under the copyright. So as such, the compulsory license under the patent was not successful even there. Next. So there are various cases where a compulsory license application was not granted for some reason or another, even due to the act of the patentee. But there is definitely a case. Here again, there is a license, compulsory license application, and the application, the patent is belong to the Novartis. No strong base was filed, and the data has not been provided. What are the efforts they've made, and then what sort of manufacturing, other things, they have not given the data and details, no statistics. Therefore, their application was rejected with the direction that they can file a fresh application. Once again, we have all the data. So even the compulsory license in yet another case against the Novartis has been rejected. The data has been given here, and then you can refer those things next. Because of shortage of time, I need to go very fast. This is the soft summary. Here is one successful case where a compulsory license has been granted to NATCO and against the Bayer drug. And this is has been where NATCO clearly established the reason why they have to get the compulsory license. They made an attempt to get a voluntary license, but they could not get it. And there, the Novartis refused to give them a voluntary license. Sorry, the buyer refused to give the voluntary license. And as a result, they had no alternative, go to the controller for the compulsory license. And wherein which they're given excellent homework and given all the data and other things. But certain reasons or very core reasons for granting the compulsory license. One of the reasons is that the Dexaber, where the anti-cancer drug is 2,44,000 rupees per patient per month, which is something exorbitant. It should not be affordable. I think that when the cost is so much for a life-saving drug, then the obligations are it not be made available and accessible. That is one of the reasons for any patent granted. But the cost. The other the thing is that NATCO said that they are able to substantially reduce something like 1/20th of the cost of the Bayer drug, and then this substantial reduction. And see, even on public interest, on a humanitarian basis, and then life-saving drug, it ought to be made accessible and available at a reasonable cost, affordable cost. And then when NATCO said I able to provide it, that was one of the winning points. Yes. The second reason is that the buyer is not manufacturing in India. They have been supplying it by way of an export. And then they're not exploited manufacturing in India. They're not made an effort to make the drug available in India based on the Indian patent, accessible, available, and then also at the cost. They not make serious effort to make it accessible only by way of they wanted to have the access of this drug, and there is a shortage of this drug, and it was not available. And some of the reasons were in which the controller eventually granted a compulsory license for this. So based on that, and then they went to the Bombay High Court and then also the Supreme Court. It has been the license, the decision was upheld even by the Bombay High Court as well as the Supreme Court. So the Indian IPR rights, balancing opportunities and balances. This is the most important thing. It's probably one of my penultimate slide, that IPR rights, the statutory right, and by way of practice, provide several advantages. Other things. See, IPR rights, even yesterday, Dr. Chitra has mentioned that it is, you need to use all kinds of IPRs. There are other kinds of, like even the trademark, talked about it. And then there are extensions of trademarks, like you have the packaging, and then also we have well-known trademarks. Some of the rights are being very powerful rights, like shape of an article that can be trademarked. So those are the things. So you have a particular packaging or a color combination, and that could be a sort of long and continuous use. They get a trade dress protection, and that is an exclusive protection under the trademarks. So the IPR rights, you have to use it collectively and provides a lot of statutory the rights for the APIs, API manufacturers to protect the inventions, protect the commercial rights and interests. And also, there are a few challenges at present. See, the law will have to evolve. There are challenges in the enforcement. There can be delays. There are other statutory limitations, artificial exclusions, pre-grant, undue limit. I mean, like unexpected delay in case of pre-grant. But the government is working on those issues. They will try to now pick those loopholes and provide a better protection and a better management of your IPR. But there are ways and means to convert challenge. It's always with, of course, I have to thank you. Yet another one more slide. Sorry, I exceeded today because this subject matter is so vast, and that we can only touch only a glimpses of it. We can talk about it for days and days, but probably we can meet you in the next occasion. But here it is, an opportunity will say that the glass is half full. Of course, it's half empty. the patent attorneys or the patent uh, that we are concluding the second session. Sorry, it's quite a long session. Yeah, only the surface we are given it, but there are in-depth studies. We'll be able to take it in the next session if it is possible. Thank you very much. And then now the question and answers. The forum is open for any questions.
Are there any questions? There is a question on APA portfolio initiation building. APA portfolio initiation building to synthesis patent for a known drug. Okay, so I will take this question. So how will you start a portfolio for a known drug? So you're talking about synthesis. When you're talking about synthesis, then it will be a process patent. In a process patent, the novelty has to lie in the process and the inventor step has to lie within the process. Okay, so in such claims, what you can do is you can talk about the synthesis, the various steps and the procedures. And after the various steps and procedures, then you can claim that particular process patent. Okay, if the is novel, you cannot have a product claim. Any other question? Main claim will be one or more can be taken, which can be followed by dependent claims. Actually, you are talking about, the principal claim and the dependent claims. In many parts of the world, you can have as many principal claims or independent claims. It is actually called. Principal is the first claim. There can be only one first claim. But for dependent claims, usually in US, there is 3 independent claims allowed. You can have 20, but then there is an increase in fees after 3 independent claims. So every jurisdiction has some restriction in terms of fee or in terms of practice. But otherwise, if you have too many independent claims, it can also trigger a unity of rejection. So what happens is usually for every aspect of invention, like if you have a product, if you have a process or a composition or a utility, for each you will write one independent claim, and that's how it is. In India, by way of practice, we make all the claims dependent on the principal claim, and the principal claim is drawn to the subject matter where the novelty and the inventor step lies. It's a pleasure. Any more questions? We had projected our email IDs. You can write to us through CII if you and your. I have one question, ma'am. In case there is an industrial design and technical information as well, what to file first? It's a very good question. Both patents, that if design publishes, it is a death knell for the utility patent. And if the utility patent publishes first, it's a death knell for the design patent. So file them simultaneously. Okay, there is a craze in which, the croc chapels that we wear, the crocs, they lost a utility patent application because they filed design first and the design was published. So whenever you have both industrial design and technical information on the same day, file both so that one does not become a novelty destroying document or a prior art to the other. Pleasure. See, in case of designs and patents, there is a question, is there any sequence to file other IPs as well? So in case of patents and in case of utility and design patents, novelty is very important. You have to give the disclosure first to the patent office. But that's not true for trademarks or copyrights. For trademarks, use can be, the more use that you show, it's better for you. So you can go ahead and file it anytime. Okay, there is nothing like novelty in trademarks. In case of copyrights, there is actually no need to file. But people file copyrights because when you go to court, it becomes very important that you have copyright in substantiating the copyright. So there is no order. You have to do, patents, both designs and utility together. Others can be done subsequently. You would like to add anything, sir?
I want to take more questions.
There's one more question here. It's asked what kind of patents can be filed for display work. Okay, so we work with many clients for in silico computational models. It's a challenge. Okay, so in an in silico model, what happens is in silico model is on the border with AI. And if you're just going to say that by docking studies, I found the drug, it becomes very difficult for us to establish. So maybe if there are 1,000 molecules, you have screened those 1,000 molecules and come up with 10 molecules. Okay, those 10 molecules you need to exemplify, and those are the molecules that you can claim. Okay, so if you're going to ask for in silico for 1,000 molecules, it's something very difficult. Okay, what you can try to do is to build a lead molecule with in silico, and then use that as a general chemical structure that will ask for exemplifications. This is not only true for India, it is true for across the globe, including US and Europe. So this is something a little difficult. It can form the base. Mr. Karthik, if there are no questions, we can close the session. If there are any further questions, Mr. Caleb and I are open here today and also by emails. You can perhaps collate all of them and send emails to us. We will be happy to answer.
Thank you for this wonderful, ma'am. Uh, Thank you, Chitra ma'am, and thank you, Gabriel sir, for this wonderful 2 days session on expert session on API and silent protection. So I will take this pleasure of being on board with you, understanding how API can be protected or how the things can be done. If we have any other queries, we'll see. So thank you for this wonderful session. Okay, ma'am. So I'll be ending the meeting now. We'll be sharing a feedback link as well for session 2 for all the participants. Please fill your feedback form to receive your certifications. Thank you, everyone. Have a nice day.